the first lecture, and this is the outline for the first lecture. I believe those of us at the back can see the screen better now. So, first question is, what is a crime? Has anybody ever committed a crime in this place before? Is there anybody who has committed a crime here before? Nobody? If God should ask this question, will the answer be the same?
God, no.
The answer will not be the same. So let me stand, even though I'm too young to stay in the position of God. Let me stand in the position of God and ask, has anybody ever committed a crime here before? Nobody.
Of course. Crime is different from morality.
Somebody is online.
Yes.
Okay.
Yes.
You've committed a crime before.
God will put the question differently now. You ask, have you committed this sin?
Okay. Because I'm not God, that's why I cannot put it in the way God will put it. And that's what I'm asking. Just permit me in the way I've asked it.
So we need to know the definition of crime. Is it offense of crime?
That's where we are going to. The definition is what we want to look at, and that's why I'm asking that question.
Well, for me, as far as I'm concerned, I believe that the crime is what is against.
No. I'm asking the class, has anybody ever committed a crime before? I've not moved from that point. I want answer first.
I'll stand down for now.
You stand down for now. Okay. Just move along with us. I'm sure the next pope is going to emerge from this class, because all the people here, they are saints. Even those online, they are all what? They are saints. Okay, that's good. Now, but I know deep inside of me that all of us here, one time or the other, we've committed one crime or the other. That's why the man online wanted to say, what is the definition of the crime? Is it morality? Is it this?
Actually, sir, we committed crime because sometimes we drive in Lagos and we beat traffic and they arrested us. So it's a crime. Is it
all of us that drive on Lagos Road? Speak for yourself first. Okay, that means you identify that you have committed a crime before. Traffic crime or traffic offense. How did you know that it was an offense or a crime?
Because it's stated and stipulated by Lagos law, and everybody can see that when you do this is the punishment, because there's punishment attached to it.
Okay. So somebody has just told us that the reason or how he got to know that it's a crime is because it's written in Lagos law that it's a crime. And that when you are doing it, of course, you know you are doing something against the law. Now, I think that's a good point to start. And then, let's ask ourselves, generally speaking, there are things that we consider as crime, even though they may not be like a crime in the eye of the law. But from a general perspective, when we're talking about crime, it is a conduct that the society prohibits. those conducts sometimes may be moral. As a Muslim, for example, you are at liberty to marry about 4 wives, right? Am I correct?
Yes.
As far as you have capacity, you are covered. But if you are a man that is not under that law, under the provision or the religion that allow you to do that, and you have a wife at home, and you now have another woman somewhere in Shagam, that is meaning that you have 2 wives. Let's just call the other one 2 wife, because wife is what? Let's just say wife is also wife, irrespective of how, whichever way she has emerged. The society, and anytime you want to go and see that woman in Shagam, you probably tell your wife that you are going for a business meeting at Oregun. Abi? Or can anybody tell the wife that I am going to see my girlfriend at Shagam? You are laughing. I'm asking. Can somebody say that? It depends. I didn't get that. If there's an arrangement. Okay, let's move from the fact that there was an arrangement under normal circumstances. Can the man tell the wife that, honey, I'm going to Shagam, I want to go and see my girlfriend? No. He will not do that. Meaning that if he wants to go, he will probably not say that he's going to Shagam. Right? Yes. Where will he say he's going to? Oregu. Going for a meeting. After all, what you are going for is also what? A meeting. When people are experiencing something and saying it, you will know. That was why when I was asking at the beginning, but now the truths are coming out. So, he will go to Shagam and pretend that he was somewhere at Oregun for a meeting. Even his neighbor will not know. But let's assume that when he was telling the wife that, honey, I'm going to Oregun, I want to go and have a meeting, and I said, okay, God go with you. And then as he was stepping out of his compound, he saw his neighbor. Neighbor, where are you going? I don't know if I can join you to the junction. Let's say we are living somewhere here, then I don't know if I can join you to Unilag Junction. And before you get to Unilag Junction, conversation has ensued. Are you going to get to Jibowu? That's the place I'm also going. Before you got to Jibowu now, conversation has led to I will pass through Anthony to Berger. Is that side I'm also going. Let's assume that this neighbor of his was actually going to Shagam. And before they got to Berger, they got to know that this man was actually going to Shagam. Do you think the man will tell his friend that he's going to see his girlfriend in Shagam? Why will he not tell him? Because what he's going for is not even illegal. Because we are talking about somebody who has a wife and pursuing another one, and one has 4, and we're clapping for him that he can maintain them. The society is not against that man for having 4, but the society is against the one who is managing 2. Why? It's because the society believes that if you want to marry that woman, marry the woman properly, not the Oregun Shagam scenario. So the society will condemn, or let's say eventually they journey to Shagam together. And then, after dropping him off, he also went his way. And one thing just happened, that the neighbor found himself in the house where the man was actually going to. You know, when God wants to catch somebody, there's nothing that cannot happen. The man will end up looking for story to cover up. Why is he covering up? Because what he's doing is not something that the society approves. In society, if you are a Muslim, you can marry as many as 4. The religious law of Islam is not against it. And then this one is trying to get additional one, then the society is against it. Because the man has violated the code of the society. And that is why he's doing it under the dark. Now, but what he's doing, does he amount to a crime? That is a question. To you, it is a crime. As a matter of fact, to his wife, it is what? Because I don't know if there's any woman who will be happy sharing her husband with another. I don't know. Women, I said we should ask you. Will any woman be happy that is happening? Man, you are not answering me now. Oh, Barry. But I will always go with, if there is no agreement, the woman will never permit such a thing. But it is a crime to the woman because, number one, you have sworn an oath to be with me alone. Now, you are now going out with another woman. And then, let's assume that one thing led to the other. The individual was discovered and exposed. It becomes a societal shame because the individual has violated the societal code. Yeah. So, generally speaking, anything can be likely amount to a crime. If we are speaking generally, somebody can call a boy who is doing boyfriend and girlfriend that is committing a crime. May use the word loosely, but under the general definition, a crime can mean something that is morally reprehensible, and that's why we classify what that man is going to do in Shagam as a crime, and then it brings injury to the society. One of the reasons why the society will not approve of such is that it can lead to a lot of societal vices where there is no longer commitment in the system of marriage. And then a young man is growing up, he's saying, I want to also have a girlfriend like my father. And usually, when children result from such avenue, they don't get the best of care, and they eventually become nuisance to the society. They become armed robbers. They become, name them, terrorizing the society, and those things that they do amount to injury to what? To the society. And that's why sometimes you are afraid to drive past some places. If you are not careful, they either want to extort you. If you are driving a car without a plate number in Ojota Road, you better be praying that there is no traffic. Because if there is traffic, those guys will come from nowhere. And if you don't give them money, they'll threaten to break either your side glass or side mirror if you don't give them money. Why? Is it a crime to buy a new car? Is it a crime to drive a car that you've not been able to obtain a plate number for? But that's what the society, that's what we are faced with in the society. You now, let's assume that all of us here now, we are still young people who are growing under our parents. They sent you to school. Will you find yourself at Ojota dragging money forcefully from somebody? No. It is those who have been exposed to those things who will do it. What I'm telling you, I've experienced it before. And immediately they came, I was afraid. I didn't even know what was happening. They were hitting the car. Give us money, give us money. Out of fear, I brought out money. And immediately I gave them like this. Another set came from nowhere because they believed that this one na mugu. So it got to a point on that spot that, and I asked myself, what is happening here? They were threatening to break the side mirror, and I was saying, what is it? What is it? What is it? I don't know how I escaped from that scene. That is the society where we live in. But what are the things that has led us to that? It is usually from acts that are morally reprehensible, that are committed in the society, that leads to such incidents. Because many of them that they are there, if they are probably educated, they will not be there. So the society will classify anything that will bring injury to the society as a crime. That is the general definition of a crime. But that is not our focus. Our focus is the legal definition of crime. And just like we have it in our slide, a crime is a conduct prohibited by law and punishable according to the law. And that's why when our brother who spoke to us online said that the reason why he can say that he was committing a crime is because what he was doing is written in the law that you should not drive on such road. So the legal definition of a crime is that it is a conduct that is prohibited by law and punishable according to law. Therefore, nothing is a crime unless it is written in the law. And not just written, the punishment must be provided for. When we get to in that second lecture, we'll be talking about general principles of criminal law. We will deal more with this. So, the law must proscribe such a conduct before it can be deemed to be a crime. And that's why when an individual is being arraigned in court, where an individual has been found to have committed an offense, suspected to have committed an offense, or alleged, they take the individual to court. And then when they want to inform him of his alleged offense, which we call charge, they will read the charge to him that you, Mr. John Okoro, on the 21st day of March 2025, at number 1 Oregon Road, did stole the property of Mr. B and thereby committed an offense contrary to section 1 of Lagos State Criminal Law and punishable by section 2 of the same law. Are you guilty or not guilty? That is the form that the charge we read. No charge in law will be complete unless the provision of the law that proscribes such conduct is stated, and also the punishment prescribed. Now, class, tell me, why do we think that is necessary? That the law must state it, must state the offense. Why? Anybody?
I do it for clarity.
For clarity. Yes, can you expatiate more on that?
For me, I just think that it is necessary for the law to state that in very clear terms, so that even the offender will know what he has done.
Okay.
And possibly the fine.
Okay.
That he has to pay.
All right. So the person who spoke said it's better so that the offender will know what he has done and the price that he's supposed to pay. Yes. What other reason? Yes, sir.
Not be any biasness or interest.
Okay, to take away issue of bias, because if you do the same thing, they can give you punishment that is 10 times more than what they give to somebody. You know, in this country, despite the fact that we have our laws written, we have the punishment written, when we are still delivering judgment, we still turn it upside down. Yes, what other reason?
Consciousness, to avoid violation.
Okay, that is an angle to it. Like I usually say in my class that many of us are not armed robbers because we are afraid of what will happen afterwards. You don't know. You will have ordinarily want to commit a crime, but you know that once you are caught, the consequences may be beyond what you like. That's why he says, I beg and who do. Even when you don't even need to kill, you just need your biro to change figure, and the alert will enter your account. You will say, no, I will not do. Why? Because if I venture into it and I'm discovered, not even in this era of social media trial, first of all, the face of the person will first of all go viral. And then, you know, some of those things, they constitute permanent records. And then the question is, how will such an individual live in a society? So, therefore, there is need for the individual who knows that this is written and these are the punishments to refrain from what? From doing. I like that point very well. Yes. What other reasons is in support of this position, that the law must state what the crime is and the punishment? Well, I think one of the reasons is to avoid arbitrariness. Because number one, when you are in power, when you say, I like to say that power is very powerful. Do you agree? Yes. That power is what? Power is powerful. Don't look at the English, but just look at what we are trying to say. When you are in position of authority, the tendency to abuse your power very high. So, to avoid arbitrariness, even with the fact that these laws are written, we still engage with a lot of issues relating to what we are saying here. That's why when guys during election, they commit election infractions, they lock them up. A call will come from somewhere that they should what? They should release them. But sometimes they are not able to do that because the laws have been the law has provided what will amount to an offense and the punishment therefrom. So having that understanding, Then it's important, therefore, for us to look at crime and civil wrong. There's crime, there's civil wrong, there's even morality. The case of Mr. Shegun that said he was going to Shagam, and I was going to Shagam and said he was going to Egbeda, is a case of moral. So we look at these three items, the distinction between them, and then it will further strengthen our foundation on this journey. Number one, a crime is a conduct proscribed by the law. Civil wrongs are conduct in violation of civil obligations. For example, breach of contract, negligence, defamation, trespass, contract of employment, hire purchase, and so on and so forth. In Nigeria and all over the world, all the things that we have listed will always happen where people cannot keep to their end of a bargain. You have engaged, you have employed an individual, and it's in the employment letter that the individual, when his services are no longer needed, we have to give him a notice of 2 weeks, informing him of the fact that his services are no longer needed. And suddenly you just wake up and just ask him to go. That is a violation of a civil obligation. It's different from when you take something that does not belong to you with an intention to permanently deprive the owner of the property in it. You can take the phone of your neighbor now, and what you just wanted to prove is that you are always too careless. Right? There's an intention to do what? To return the phone. You just wanted to make a statement. But when you take it with the intention to permanently deprive the owner of it, you have committed a crime. Friends too, they usually steal their friends' property. I've been a lie. I once had a friend in my secondary school. We do everything together. We go home together, we play together, and this young man stole my commerce notes. I cannot forget. And he removed the bag, created another bag, and folded and wrapped it powerfully. And he was using that thing in the same class with me. But of course, because it's a stolen property, you are never free to use it openly. How did I know? You want to know? Everybody like gist. I will tell you the ending of the story some other time. Or let me just say, I just saw somebody copying notes from the notes. You know, those days we borrow notes, Abi? Yeah. He borrowed somebody, and the person was copying from the notes. That was how I saw my handwriting. I said, this is my handwriting, okay? By the time I picked it, I discovered that this is the note I've been looking for. May God expose your enemies. Amen. The young man had the intention to deprive me of the property in that thing. Why? Because of his actions. That thing was away from me for more than 3 weeks. And then he has removed the back. And that's why the law will hold on to you. If you take somebody's property and you alter it, maybe you took somebody's shirt, long sleeve, and you reduce it to short sleeves. You have already altered the makeup of that property. It can never be what it used to be. You already committed a crime. So the point is that all of that will fall under crime, while some acts will fall as civil wrong. Number 2 point we need to make under crime versus civil wrong is that object of criminal law is to punish, while that of civil law is to redress. I've not seen in this country where government now call you and say, Dr. John Obayagu, we hereby give you the sum of 2 million naira for being a good citizen. Has anybody ever received such a fund from here before? No. But when you commit a crime, the state will deal with you. So that is the focus of criminal law. On the other way around, civil wrong is to seek redress. The man who has been sacked wrongly is asking that it is either is reinstated and asked to leave based on the agreement between them, and that, okay, you have caused me some emotional trauma by reason of sacking me without even giving me an opportunity to say what, to defend myself. So the purpose of whatever argument will be for compensation or to seek redress, which is the general term that describes that. Number 3, difference or position is that crime is punishable by the state, while civil wrong is remedied by private arrangements. When you commit an offense, it is you against the state. Whether the offense was committed to a third party, the man that, I think it was just this past week that there was news that the man that killed the young lady that was on BRT, Bamishe or something, was sentenced to death, right? This week. It was not the parent of the lady that was pursuing the case. It became a state matter because every crime is against the state. Because the state holds a duty to every citizen in terms of protection. That's one of the primary purpose of government. So the crime is against the state, but civil wrong is remedied by private arrangement. What example can anybody give me of private arrangement in seeking, addressing a wrong? Yes. I didn't get that. Please, just 1 minute. Yes, online. Go ahead.
Following from the example you give to us, if you take your friend's phone,
yes,
and you, between both of you, you agree to return it back without involving the law enforcement agency.
Well, that may not really fit into the explanation I want to make, because that one is just like both of them are playing. But let's give examples from this floor that will help us to. So I will come back to you. Yes, sir. You wanted to say something.
I said my Lagos is now addressing agency called Citizen Mediation Center.
Okay.
So that is to address some issues.
Okay.
Between the husband and wife.
Okay.
Between to do that matter it's not a crime.
Okay.
It's just a civil
Yeah.
issue. So that's it.
Have you taken someone to meditation before?
No, because I don't have any issue.
Yeah, I was just asking.
I'm not want to have it.
Okay, now let me give you an example. What's the name, sir? Mr. Force. Let's say Mr. Force is a contractor. OTB has approached him and said, I have some containers in China that I want you to move to Lagos for me. And you said it will cost 50 million naira. And I gave you 30 million naira. You said it will be delivered 1st of May. And then 1st of May, no show, abi? Second, no show. Third, let's even add S to the show. No shows. Till now, there is no shows. If ordinarily I will be agitated, and then probably you can come and say, okay, I have issues beyond my control, right? Let's do it this way. I will engage a company to deliver that material, but I want to engage, but the cost they are asking me is more than what I have bargained with you. So, but I'm ready to bear part of the extra cost because I have caused you the delay. And you said, okay, now they are asking for 60 million. I will do 5 million as my own contribution. You will do 5 million as your own contribution. That is a form of understanding, right? To resolve whatever the issues were. Let's even say that you take me, I happen to take you to court. Do you know that at the end of the day, the court can either ask you to deliver that product at all costs, number one, or refund my money, or bear some consequences of your action. But one way or the other, it's not that the court will punish you for being unable to deliver that material. Because number one, you are not denying that you took the contract. But what you are saying is that there are circumstances beyond what your control. No law will punish you for that. So that is what we mean by remedied by private arrangement. We were in court last week, and the tenant we took to court said he wants to leave so time. No problem. Let's enter terms of settlement. We entered, we drafted it, and he signed. And the court will admit it next coming week and make it the judgment of the court, without even the court having to force us to go through the rigors of trial. That is because it's civil arrangement. But for crime, it is not so. Except that by virtue of the development in our jurisprudence, legal jurisprudence or criminal jurisprudence, we have introduced things like plea bargain, or we have introduced things like settlement out of court. That's why, and I think, we may some argument may support such plea bargain. Why some people like us will be against it. Somebody will steal billions of money belonging to Nigerian people. Then you will now say you should pay half of it and go. I saw the estate that was taken from Ebefele. That's the name they are giving him. He has different names anyway. But no, I don't know. I really don't understand some things. I don't know whether you can help me to understand. I don't know if you saw that estate. You saw that somebody. And that is one. And you know that you can never discover all the things that the man must have done wrong. How you want to know? You cannot know. For all you care to know, that estate may not probably not be the sole property of that man. But as the man come out to say he's not the owner, when there are people that are behind him for that project. Now let's say we want to do settlements. You know, say, okay, I'm ready to forfeit half of it. Tell me why people in this class, if they become governor of Central Bank tomorrow, they will not build triple of that. Because they know at the end of the day, if they take half, that half self, they overreach. And that's one of the reasons why we are where we are today. And I do not really think that we are going to be any better. Because the more you steal, the more the society will give it to you. The more society will worship you.
There are no consequences.
There cannot be consequences when even the people that are supposed to match out the consequences, they are also corrupt. Number 4, crime is within public domain, while civil wrong is within private arrangement. Like we have said, anything that has to do with the state is public. That's why when we talk about classification of law, we talk about public law and private law. Under public law, we have laws like constitutional law that deals with, constitution, deals with component of state, arms of government, that deals with people. They talk about law of contract, that is practically an arrangement between two individuals, like landlord and tenant. Even though now the government of Lagos is going deeper into that kind of arrangement. So for those of you who are living in a rented apartment, if your landlord wants to collect money, they say they cannot collect more than 3 months from you. But before you drag it, make sure you have built your own. Make sure you have built your own. As a lawyer, as I stand now, I don't know whether that law exists, because the practicability of it is what the government need to look at. If you want to obtain building permit in Lagos today, if you get that building permit in 2 years, that means you know people. And when you eventually get a permit, you want to start building, different tax forces will come. And some, if you don't pay, you cannot continue. Then, when you finish building, government will now tell you how you will use your thing. I wanted to ask a question, but I will not ask.
Please go ahead.
No, don't let me ask.
Please go ahead.
What we are teaching.
Let's all learn. Let's go ahead. Let's all learn.
It's not to ask me.
Are we all right? That's the question. I had a privilege to read the thesis of my colleague in the Faculty of Law here, Dr. Isari Brokun. He won the best thesis in the convocation before the last. He wrote on rent control as that's the topic about Lagos State. And in the course of my reading it, he proposed a theory, because of course some people said theory should be that the landlord should be free to determine what he wants to earn. Then some will say, no, the welfareist theory. Why don't we consider the tenants, consider the landlord? But there is a third party, which is the government, that plays a vital role. He now said that the only way you can enforce a rent control that is meaningful is a control that takes care of the interests of every party. If I want to build in Lagos, you make it easy for me. Yes. It's just like you are chasing a woman and you want to marry the woman. That's why when man is chasing a man, the woman will be doing like this. Immediately the man gets the woman, the man will now relax. Now the woman will now be doing the chasing. That's why I advise people, don't allow them chase you too much. because it will bounce back. So, what are we saying therefore? Each party should be put into contest. That's the only way you can be fair. When you make a man go through trouble to achieve something, that's why even we as Nigerians, we are the one creating problem for ourselves. When a man wants to contest to become a senator, he will tell you that he spent 100 million for this constituency. Then when he gets into power, you will not tell him not to take his money back.
It's an investment. There should be a return on investment.
When Buhari was contesting to be president, he was spending paper sweet. Sweet wrapper. Abi, was it paper sweet that he was spending? He did the first one. Did the second. Did the third. And then when he now won, he now said he should do appointment of federal character. It cannot work. People finance those elections. One way or the other, they must be compensated.
Investors.
It's even possible that some of those investors are in this class. So don't let us delve into the problem of Nigeria too much, because we will not go finish. So, number 5, the punishment for crime must be provided for by the law. That's why we said if it is not provided, then it cannot be an enforceable law. And then for a civil wrong, the attendant consequences need not be stated in any particular document. Why? Because it's usually an arrangement between parties. There are landlords who will tell the tenant, don't pay. Abi, you just do this for me. Don't pay rent. You say, if you can come to my farm and work for me, don't pay rent. If the person is a woman, there are other ways they can pay, which is usually an arrangement between the two individuals. Number 6, there is presumption of innocence in a criminal trial, but not so in a civil trial. The law provides that for every alleged offense, it remains an allegation until it has been established. But it is not so in civil wrong, because a man can be telling a lie and he's saying it as if he's saying the truth. Has anybody done that here before? Yeah. Did he? No, they are here. They said they are here. You know that, okay, for example, there's a case we are handling. And that's why when you are telling lies, you just know that you are either selling yourself. If the person you are dealing with is going to be a smart person than yourself, you enter a contract with somebody. You send the document through WhatsApp. The person signed and return it back to you. Now there's a breach. We have sued them. They now went and altered the documents that they purported. They said was the terms and condition of the contract. Because while we were filing, we never told them that we were still having that original document with us. So it was a ploy to put them out to say something that will now use to attack them. They thought we didn't have the terms and conditions. They now filed. When they filed, they attached a cooked terms and conditions that they've changed everything. Meanwhile, we have our own that was the original one that they signed. So what they are trying to establish is that they are even trying to prove what is wrong with a wrong document. And that's what we're talking about under civil trial. When you see a case, when somebody finish telling you their story, sometimes you say this person has won. Meanwhile, everything is full of what? Of lies. So you don't presume any of the two parties as innocent, because both of them can even be telling lies at the same time. But under a criminal trial, whether the judge saw the accused person when he was doing the offense, he is still deemed to be innocent until established by the state. That is, of course, how the law has put it there. We cannot at this point alter it. Number 7, the burden of proof is on the prosecution in a criminal trial. While in a civil trial, the burden is on the party who will want the court to decide in his favor. You are a landlord. You have a tenant, a stubborn tenant for that matter. And then you have served him the required notices to quit. He's not going. And you took him to court. When you go to court, he said you never served him any of those notices. If you want the court to give you judgment, you have to show or prove that you indeed served on him the notices. How you are going to do the establishment is your own business. But for a criminal trial, the burden of proof is on the state. And that's why it's always sometimes difficult to achieve conviction, because people can destroy evidence. People can do a lot of things to make it impossible for the state to prove. When I was a youth corps member at Rivers State Ministry of Justice, we were doing a kidnap case. I was for the state government because I was serving in the Ministry of Justice. This young man was arrested for the kidnap of an individual, and in his defense, he said he was not in Port Harcourt when the incident happened, that he was in Lagos, that he was attending amnesty program. Number 1, in the mind of a judge, people like you cannot be attending amnesty program. Can you be attending amnesty program where they are doing rehabilitation, or can you be there? The only time you can be there is that if you are part of those facilitating. So for that man to have said he was part of those attending the program, meaning that in his personality there is criminality there. So when he gave us that story that he was not in Port Harcourt when the incident took place, how then do we establish he was the one who orchestrated the kidnap? Of course, when he was arrested, they've collected his phone. And then, in the course of questioning, they asked the security man, who happens to be an Aboki man. I think from what I have seen, the natural Hausa man is a plain person. When they asked him what happened, he said it was his oga that called him that his friends are bringing something, that as soon as they get to the gate, he should open for them. He did not know whether it was human being they were bringing. And of a truth, when they came, he opened the door for them, the gate for them. They drove in. And he said when they drove into the compound, they brought the car back for him to come and wash it. That it was when he was washing the car that he saw gun under the, I'm telling you a life story, that he saw gun under the carpet of the car. You know all those cars that they use for all those things, there are different places they hide there. The police officers here will know what we're talking about. So Oga, you said you were in Lagos. How should we then prove? Because he has raised the defense of alibi. That's one of the, when I was giving the introduction to this, we'll talk about defenses to criminal liability. One of the defenses is alibi. As you are here now, nobody can say that you are committing a crime in your house. Why? Because you are not there, you are here. Of course, there are CCTV cameras that saw you while you were even probably entering these premises. So it was difficult for us to say that yes, this man indeed committed a crime, but the burden of proof was on us to establish. What then did we do? We simply did like a call log analysis, and then we brought in NTN to determine where the call that the security man received, where it originated from. And the call, if you make a call here now, and your initiation point and destination will be known by the service provider. That was when they discovered that the call originated from somewhere in one of the rooms in Port Harcourt or whatever to that man, and we presented that evidence. When they have in Yoruba, you don't be looking, and that was just it. So the body will continually remain on the prosecution. Though the burden of proof sometimes may shift, because when the man said he was not in Port Harcourt when the incident took place, what the process we do is that the body will move from us to him to establish that he was in Lagos. So he provided evidence of the materials that they were using at the amnesty program. But the fact that the call originated from within Rivers State is a kind of is a prima facie evidence that he was indeed in Rivers State and not in Lagos State. So the burden of proof will always is on the prosecution, but sometimes it will change. So that's why at item 9 we said the standard of proof in criminal proceedings is beyond a reasonable doubt. Why in civil proceeding it is based on preponderance of evidence. That is, claimant must prove or produce evidence beyond the balance of probability. What is the balance of probability? When you have a scale that is like this and it's even 50-50, it's going to have like the same balance. Yes, 51 against 49 will no longer be not balanced. So once there is an imbalance, of course you know that the one that is having like the highest whatever will probably carry the day. So for you to win a case under the civil proceedings, what you just need is it's not an overwhelming adjustment of the scale, but in criminal it must be overwhelming, that there is no need, no iota of doubt. Now the story I told you, if MTN had come to court to say that when we were doing our analysis, we discovered that day our system crashed. We can only pinpoint where the call was received and not where the call was made. That would have been the end. Because a doubt has been created as to where the call originated from. So that is the case with the standard of proof under the criminal proceedings. Then we continue. In criminal proceedings, a guilty defendant is subject to custodial or non-considered punishment. In exceptional cases, death penalty may be awarded, but the reward in a civil proceedings is usually compensation. Sometimes it's financial for the injury that the individual must have sustained in the course of the civil wrong. The punishment that was given to that BRT man is a death sentence. Some, they will ask them to go and do life imprisonment. Some, they will ask them to go and do, even if it is 5 months in prison. But in civil wrong, it is not so. It can either come in form of compensation or what we call a contract specific performance. That is, just like the example I gave between me and Mr. Force, the court will compel him to fulfill the contract at whatever it is. Now, we have been talking about crime and what? And civil wrong. Now, let's look at crime and morality. I gave an analysis or a story of a man who was seeing another woman outside his wife. Yes, I have a question. So, I gave a story of a man who is being unfaithful to his wife. He was going to Shagam to see another woman, but he told the wife that he was going to where? Oregu. Now, like I said, it's morally reprehensible that you have a wife at home and you are still doing another thing. That the story will be different if he could marry that woman, if his religion or whatever it is that believes in permits him to marry that woman. They will see him as a strong man rather than as a morally corrupt individual. Because like I was watching a skit yesterday, one man said one woman is 7 devils, 2 women 14 devils. I don't know what gave him that analogy, but maybe it's because of what he has seen anyway. A woman to me also have its own definition and say one man 100 devils. So, if a man could marry 4 wives and is able to manage them, he is seen as a strong man under a protective cover. But one is legally married and is also engaging in other matters connected thereto. The society will see that he's morally not, okay. So, morality is the social, cultural, or religious values and norms of a group of people. Crime is the legal sensibility of a certain group of people spelled out in the law. Which country can we say that gayism is normal, is popular? Which country? US. Here is a crime, right? It's a crime. Now, in the US, a man and a man can be going and they are calling themselves and they are going. If it happens on our street, here in Nigeria, the people on the street may not be able to arrest them, right? Are you following me, class? They may not be able to arrest them, but they will be stalking by the side. What are the likely things they are going to say? Why are you not answering me now? You are doing as if you don't usually see things that you comment about. You will say that Eh? Say it now. Ayé ti bàjẹ́, yes. Yes. An aberration. What? Abomination. Taboo. But you will not say it the way you are saying it, so you will say it with pain in your heart. That is the kind of answer I want to get. You look at it and say Iran. But in a society where it's acceptable, there's nothing wrong in it. But morality is organic and unwritten. That's why there is nowhere it is written that you as a Yoruba man or an African man, you cannot have a side chick going by moral standing, except that our religious laws forbid that. So if you are a Muslim, you cannot do such a thing. If you are a Christian, you cannot do such a thing. But it's not written anywhere in our moral code that you cannot. But when you do it, somebody was saying that if you are planning to marry and you have gone to the house of the man that you want to marry, and as immediately you enter with the man, somebody from corner shouted, Echo, that you should know that this one is what? Casanova. The man did not say Echo is just the name of an animal. Abi? He said, Echo. He said you should know that this man, you are not the first woman that he is bringing. That is in the habit of what? Of bringing different women. But is it written anywhere in our moral, societal, or whatever that you should not bring many women? No. It's not. But the society does not approve of it. And one way or the other, it has become our moral unwritten code. Crime is not organic, but it is fixed in the written law. At the beginning we said that if it's not written, it is not what? A crime. You need to hold that in your hand. So morality deals with popular values by tending to promote the greatest happiness of the majority by prescribing certain conducts. Starting from even dressing. Some of you, when you see your children, they want to go out with a certain cloth that they are supposed to wear in the house. You may not even talk. The way you look at the child self, the child don't know, saying not the past boundary. You go inside. It is because, and in some time, that a child can actually wear that particular cloth to the mall. And then when they see him or her, he looking hot, and they will use phone to say it, and the child will be happy. We're talking about what each society accepts and promotes. Now let's move on. We'll look at the history and sources of Nigerian criminal law. Are we together, class? You have a question? Any question? Yes, please. I thought the slide has been sent to you already. You will get it. So that we don't okay? So sources of Nigerian criminal law. When we are talking about sources of law, we are speaking about the origin of our laws. How we get to where we are, the process, the procedure, or how we have come to have the body of laws that we have and that we refer to as our laws. So number one of the sources of the Nigerian criminal law is customary law and Islamic laws. we have argued and we have established both front and back that customary law is not Islamic law. And Islamic law is not customary law. But the point remains that the laws that we have now, some of them are the offshoot of our traditional heritage. I was teaching yesterday about traditional system of dispute resolution in indigenous African society, and we were able to point out that negotiation, mediation, reconciliation, adjudication are the different methods that were prevalent in the indigenous African society through which disputes were resolved. The obis in council, the obas, the baales, they all played what? Specific roles in dispute management. And that the system we have now, which can be tagged the modern system of dispute resolution, were things that we derive from our indigenous practices. There are some people now, they don't want to go to court. Once anything has happened that we warrant them to go to court, they will quickly look for a way to resolve it. Now, in those days, there was no formal court like what we have now. But we have a show where you have to go to the shrine, which is the court. And then, you know that when you get to the shrine, whether you say the truth or not, one way or the other, the truth will come out. I saw a skit where a man stole another person's chicken. Stole his neighbor's chicken. And the neighbor started looking for it. Nobody said anything. Until he now threatened that if that chicken does not come out, I'm going to so place where they will reveal the identity of the person that stole it. So he left the compound and he was going to see an herbalist. While he was on his way, he got a call. And one of the neighbors said, "Can't we play with you again?" He quickly changed the whatever that he was actually playing with, because they knew that he knew that if they should pack all of them to the shrine, the Amadiwa will conk the one that stole the chicken. He quickly was confessed. So, and one of the things we need to note here is that before we were colonized, we as a people, we had our own system of laws that worked for us. Yet, they may not be sophisticated as what we have today. They may not be as properly codified in a different document that we call today. They may not be called ordinances. They may not be called statutes. They may not be called acts. They may not be called edicts. They may not be called decrees. They may not even be called laws. But they were effective in resolving disputes between individuals. And of course, those practices in our customary system till today still influence the laws we make. Recently in the Delta State House of Assembly, there was a law that was in process to be enacted. And the law was on the fact that if a child is seen on the street walking or moving or selling between so hours when he or she is supposed to be in school, that the parent will be I don't know whether the parent will be punished or something. But I'm not sure the law couldn't go through because, number one, do you know the state of that woman or of that man? You, as a government, have you provided a platform where the children of the indigents can successfully go to school? Or are we saying that the school feeding program that we are doing, can it make people to go to school? When you see what they are serving them, you probably not even want your kid to near such schools. So the reasoning was that, why do you want to punish a woman or a man that is already being punished by poverty? So I think the law could not skate through and all of that. So customary law, Islamic law, because there are aspects of Islamic law that forbid some of those things that we criminalize in our laws now. Islamic law does not permit adultery. It doesn't permit quite a lot of things which are now part of what we have in our system. So, one of the sources of Nigerian criminal law is the customary law or an Islamic law. But please note that customary criminal law has been abolished by virtue of section 3610 of the 1999 Constitution. Okay, so we don't have customary criminal law. One of the major reasons is because customary laws are largely unwritten. And you will recall that before anything can amount to a crime, it must be what? It must be what? And the punishment does what? Provided for. Customary law is not written. Let me say it's not written. It's largely unwritten. So that's one of the background fact to the abolition of customary criminal law. One of other sources of the Nigerian criminal law is the English law, which comprises of the common law of England, the doctrines of equity, statute of general application, and so on and so forth. All these laws were laws that we imported into our system as a people. The doctrines of equity, as a matter of fact, the Nigerian court as of today also practices those doctrines alongside with the doctrines or the rules of common law. That's why if you have gone into a contract with someone and then you have fulfilled your own part of the story of the bargain, before you could execute, something happened that was not like an original fault from you. Well, let's talk about a man bringing containers from China, and when he got to Cameroon, where he's supposed to navigate into Nigeria, then a war broke out there. He could not proceed. Automatically, that contract is being frustrated by an unseen circumstance. And then you are now saying because the man did not deliver as at when due, so he's liable to pay you compensation. Equity will not support it. As a system of law, equity will look at the efforts. Am I going too far? Are we together? Equity as a system of law will look at the fact that this man has taken effort to achieve or to perform this contract, but he's been unable to perform it absolutely due to some factors beyond his control. So English law is part of the sources of our laws, and till today, when you look at some of our laws, there are laws that we carried from the English system. The only thing we did was just to change the name. Maybe this law is made for the British people. They will now change it. This law is made for the people of the Federal Republic of Nigeria. As a matter of fact, our penal code, yes, is made after the Sudanese law. So, were things that we just, carried and put together. So, those are the sources of Nigerian law. We said we have the customary law, Islamic law, English law, which encompasses common law of England, doctrines of equity, statutes of general application in force in England on the 1st January 1900, and statutes and subsidiary legislation on specific matters. So all of these form the foundation of what we have today as our criminal law. Another one which is of utmost importance to us is the Nigerian legislation. The Constitution of the Federal Republic of Nigeria is one of the major sources of Nigerian law or Nigerian legislation that provides for our criminal needs. We have international treaties that have been domesticated by the National Assembly, have been ratified and transmitted into our system. Then the laws made by the National Assembly, the regulation made pursuant to laws, local government bylaws, and so on they form the Nigerian legislation that constitute part of our laws or the sources of criminal law in Nigeria. Also, we have the doctrine of stare decisis, which is otherwise known as decided cases. Once a court has given a judgment, especially maybe one of the courts of records, like the Supreme Court and all of that, they automatically become a law that lower courts must follow. Right? They must follow in adjudication of similar cases that may come before them. So, those are the sources of Nigerian criminal law that we have. Now, we move to objectives of criminal law. The slide will be made available to you. It's already on this system, so you have it immediately after the class. So the objective of criminal law, from all we have been saying since we started, you will be able to identify why there is criminal law. Number one, criminal law is to punish offenders. That's why we said it doesn't reward good conduct. I did ask that, is there anybody this class was not as full as this then. Is there anybody that has been rewarded for being a good citizen of this country? I'm not really talking about those national honors and all of that. But they just look at you and just give you 5 million for being a good citizen. So number two, to preserve public order and decency. That was why I said that practically all of us in this hall will have find ourselves doing one crime or the other as our normal life. If there is no fear that when we are discovered, we are going to face the music. Yeah. How many of us has ever been to some of the Nigerian prisons? Not as an inmate. Anybody? Yes. What about police cells? At least the police officers in our midst, we know how the place is. Some people, the reason why they will not commit crime is that they don't want to be locked up in any of those places. Because there are places that Maybe if you want to get the concluding part of my story, you can check some of those prisons or police cells. So, to punish convicted offenders, to preserve public order and decency, to protect the citizens from offensive and injurious conduct. Then, to provide sufficient safeguards against exploitation and every form of abuse. You hear different kind of scam taking place within the system, despite the fact that there are these laws. Of course, there are people who have been involved in those scams and they've made serious money and they were never discovered. But something will discover them one day, or one way or the other they live on the consciousness of how they made their money, which in turn owns them. But what criminal law does is to prevent a situation where citizens are exploited. That's why when you do what you're not supposed to do, one way or the other, if they discover, they trace every of your activities to ensure that they cut off your wings and you are not able to continue. Then another objective of criminal law is that it prevents corruption of the more vulnerable members of the society. But as I was just saying that, it occurred to me that there are some people that the criminal law cannot hold. Yeah. There are people who are walking free now, who are supposed to be in the deepest part of our prisons. Where Yaya Bello was being taken to court, they were hailing him. Abi? And then there was another man that did something that was speaking for the Nigerian people that was arrested around the same time. It was more or less crucifying him. And now the era we are in now is cross to this party and your sins are forgiven. When you cross, all you need to do now is just cross. Yes, once you cross, irrespective of what you have done, you are born again.
Can I ask a question?
Yes, sir, please go ahead.
I want to ask, is it not, if you add to serve as a teacher to others, will it be out of place?
Yes, it is part of what we have been saying. Yes, if it will create some form of deterrence, and that's why I said that many people in the society are not engaging in crime because of the fear of the consequences that will follow. So the criminal law, that's correct, helps to deter people from engaging in crime. Okay? So that is all for the objective of criminal law. Now we move ahead to look at classification of crime. Classification of crime. Now, in dealing with classification of crime, of course, number one, first of all, crime is crime. We have defined what crime is, and we still stand by those definitions. Yes, sir.
Sorry for taking you back.
No problem.
When you said that, the customary criminal law has been done away with.
Yes.
I want to ask, is it just the customary criminal law or the customary law?
No, it's customary criminal law, meaning that the customary law can no longer prosecute crime. That's the meaning. Yes, it may be able to handle other aspects of life, but it cannot prosecute crime. Like I said, one of the major reasons is because customary laws are largely unwritten, and we have said that for any crime, for anything to amount to a crime, it must be written in the law and the punishment provided for. Okay, so we move on. Classification of crime. According to Section 3 of the Nigerian Criminal Code, crimes in Nigeria are classified into 3. Okay? Now, in the time we are in, we also have what we call ACJA. What that A stands for, you have taken it away from my head. Okay, that's come back. Administration of Criminal Justice Act. Administration of Criminal Justice Act. That's a law made by the federal legislature. And we also have the Administration of Criminal Justice law of each state. Lagos is a leading state in that aspect. And now, the ACJA did not categorize crime. Okay? And the same with the ACJA. But they usually provide procedural steps that is needed for prosecution of those crimes. And why do we have to look at the classification? The classification is done majorly to expose the severity of punishment that comes as a consequence to commission of those crimes. So therefore, in Nigeria, crimes can be a felony, a misdemeanor, or simple offenses. So we have 3 classifications, and we are going to touch on those classifications one after the other. Number 1 is felonies. Felonies are crimes that are considered to be serious in nature, and they are usually punishable by long-term imprisonment, even death, and so on and so forth. The most recent case of that is the case of that man that murdered a young lady, Bamishe, in the Lagos BRT bus. He's been, sentenced to death. So what he has done can be deemed to be, is classified, not deemed now, is classified as a felony. And the incident that led to the demise of that young lady took place I think it should be up to 2 years now. About 3, right? But it is just this week, I think this week or so, or last week, that judgment was passed on this individual, because any felonious crime must go through the formal trial process. There is no shortcut. As a matter of fact, if the state should engage in any form of shortcut, it can invalidate the entire process, and then the individual may either walk free and continue to enjoy the product of his loot or of his action within the society. So a felony as a class of crime is punishable with long-term imprisonment. Is punishable with imprisonment above 3 years. So majorly when an offense is punishable with that length of years, it automatically falls under the felony as a class of offense. The second one is misdemeanor. This is punishable with a term of years not less than 6 months, but not more than 3 years. We have an example there in our slide to include assault, theft of minor items, We are not talking about those who stole to build estates of 300 duplexes. I think we should in our jurisprudence should look for a way to describe those kind of stealing. Maybe we have triple S to it, to the stealings, so that it will show the enormity of what has been stolen. Okay, so example is assault, theft, or minor items, and the magistrate courts usually serve as host for the prosecution of those offences. The third one is simple offences. All other offences that exclude the above, that is, which is not a felony, which is not a misdemeanor, falls under the simple offences, e.g., loitering, public nuisance, and so on and so forth. All of that are punishable by short-term imprisonment, and they are tried summarily. What we mean by summary trial is that you don't have to go through the rigorous procedure of trial, which could take a long time. You can imagine if that man has been in a prison custody for 3 years for a minor offense, then it will be more like a punishment for somebody who committed traffic offense to be in prison for 3 years before his case is decided. So oftentimes the court does not engage in full trial in dealing with cases like this, but rather they engage what we call summary trial. Now we are moving deep into the whole package by looking at elements of crime. Elements of crime. So, as you can see on our slide, elements of a crime are the essential legal components that must be established to secure a conviction. These elements are grounded in both substantive criminal law and judicial decisions. Now, what is the elements or the element in the offense of stealing? Let's look at that so that it will give us a better understanding as we dig deep into the lesson. Number one is that someone has taken what is not his own. Right? Number two is that he has taken it with the intention to deprive the owner of the property in it. I gave you an example of my classmate that stole my notes plenty years back, who had to remove the back cover, put another cover and wrap it so that it's not discovered. He had the intention that I will never come across the notebook. Then number three is that what is taken must be a property of somebody. Then what is taken must also be capable of being stolen. So before an individual can be convicted for stealing, he must have done all that. At least one or two of these must have been established. So what about those of us who usually pick our children's toy and hide it? For some What do we call that? It's not stealing. Okay, mothers, or is it mothers now or the fathers that we ask? Why would you do that? What are the reasons that usually lead to that? Okay, to reduce the rate of distraction, yes. Somebody is talking online. Can you please speak up? Okay, those of us in class, yes. In form of discipline. Okay. But what about those of you that will take it without the child knowing? Maybe when after the child has played with that thing, has scattered everywhere and has gone to sleep. Before he wakes up, you have taken the thing. You now hide it. It's the same intention. Yes? That's when you do it, so that I will not know. That means you have taken it with the intention for him not to see it again. Is that stealing or not? Because you bought it, so it's not stealing. So you are saying that you cannot steal what is your own. Interesting. Yes. Why will it not be stealing?
You own the child of the toy.
You own the child. You don't own the child, though. What? Are you a lawyer? Yeah, a policeman. Yes, somebody is speaking online. Yes.
I got the toy for the child.
Okay, you got the toy for the child. So because you bought it with your money, then you are not depriving it.
Yes.
So okay, someone is also saying that because you bought it for the child, the thing is not the property of the child. Can I submit that once you have bought something for somebody and you have given it to the person, the property in that thing has passed to that person. So how many mothers have stolen here?
Nobody has stolen.
Yeah. No, it is the act that is important. Yes, sir. Sorry, just a minute, sir. Hello, can we have one house? Sorry, there's person online. Just hold on, give us 1 minute. Somebody wants to ask a question here. Yes. 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 The name on the receipt is your own. You never bought a car for your wife. You've never bought a car for your wife. You bought it for yourself and gave your wife the right to use it. I didn't get that. The toy. Yeah. And boy, it has become his. But that one is just for your wife to use it. The receipt was already in your name. The toy is also, but you didn't give to your wife absolutely. Okay, now let me now say something. Let me say something. A child of 3 years or 1 year, number one, does not have capacity to contract. So you could not, even if you buy in his name, it's not a valid contract, so to speak, except we go through other means. But that one, for the virtue of the fact that that woman is already your wife, person is an adult, or is not. You didn't marry an adult, so that we know how to take you out from here. So for the fact that the person is an adult, already had capacity to contract. So your failure to purchase it in her name is an indication you never had the intention to pass the property. Yes, the person online, can we hear you? You said what?
Tell me.
I can barely hear you. And I'm running out of time. So I'll give you opportunity to ask when next you are in class or you have the opportunity. Now, let me shock you here. What you should have reflected in your answer is what is the intention for taking the thing away. The intention. Now, this element, let's hold on to the element of stealing that we have itemized. Let's go further because we use it to explain these other ones. There are 3 core elements of a crime in Nigeria, but 2 are mostly discussed. The first one is the actus reus and the menstrual, which is the guilty mind. The third is concurrent of actus reus and menstrual. Now the actus reus. The actus reus is a physical element. This refers to the physical act or the unlawful omission that constitutes the criminal offense. Now, why your taking of that toy will not amount to crime is that the intention, number 1, was not to permanently deprive that child. You may have the mind to release to the child when the child is probably a bit mature or can manage it. Now, let me explain actus reus. You have a neighbor who you consider to be a wicked person, and you want to kill the neighbor. You are saying, don't you hear news of neighbor killing neighbors? Are you saying people like that are not here? Okay, let's take, for the purpose of this class, the person is here. And that your neighbor that you want to deal with used to come to your house. And he will come and harvest all your stories, all your whatever, and go and give it to your enemies. And your enemy is now using it against you. So he has come on an usual day, and he now said, today will be the last day you will do this thing. And then before he came, you have gone to buy rat medicine. What other things can we do? Can the person use? No, now this one, the intention is to kill. Forget about this associating. The intention is to what? Is to kill. So you have gone to buy rat poison. You now invited him to come to your house. And he came in his usual way. Sat down. You have removed the rat poison and you have put it in his food. You did not make the mistake to put it in your own food. Right? When after you have finished putting it in his own, you now went to go and wash your hand. Right? Are you following my story?
Yes.
And then you now, okay, yeah, the food is ready. May they not invite you to such meal? And then the person choked with something and died. What is the actus reus? Because you were just listening to stories, you probably did not know where I was going. So what is the actus reus here? If we say that the actus reus is a physical element of the crime, yes. Poisoning, yes.
Intention to kill.
Anybody that will give me the answer I want, I will give you 50,000. Sir? Can you ask the question again?
Yes, 50,000 words.
I refuse to answer your question. Sir, I refuse to answer your question. I am the one in charge of this class. So if you ask me, if you answer correctly, I will give you 50,000. But if you answer and you fail, you will give me 50,000 naira. 50,000. No, this. Oh yeah. Yes, I'm listening. The question is from the story. Hello.
Okay.
Yes, I'm listening to you. He said this person is saying the intention is I don't want you to talk. Because I said if you don't tell me the correct thing, then you pay me 50,000 naira. For keeping quiet. Okay, now you have to talk because this is a class. Failure to not talk is even a problem now. Because if I call you, you must talk. The question, yes, the brave people will always ask and they will give me answer. The question is, from the story, identify the actus reus. The rat poison. I will not take that. Yes? Murder, no.
Intention to kill.
No.
Putting poison into the food and serving the guy.
Please give her 50,000 round of applause. You didn't hear what she said. Please, ma, can you repeat it?
Putting the right poison into the food and serving the guy and serving the guy to eat.
You didn't hear? She said, putting the poison inside the food and inviting the person to come and eat. And I said you should give her 50,000 round of applause. Either you don't like her. All right. We have clapped for her in the spirit. Now, when you said rat poison, I said I would not agree. Rat poison can be somewhere and it will not do harm. But you have moved. The rat poison does not have leg. It does not have hand. So your movement of that thing to the right place, not your, you didn't make mistake of putting it in your own, constitutes what the physical part. So when you see a crime, from what we have said, you should be able to identify the what, the actus reus. And look at it. Look at it. Here, he said it must be a voluntary act. That's why when she said you pick the rat poison, you could have picked another thing. You could have picked shield bottle of malt and put it by the side of the food. But you picked, it was not a mistake. So then again, that's one side. Another way where you can also be guilty, or you say what? Are you with us? Okay. You have caught my flow now. Okay, another way to it is that actus reus also include not only physical action, but also failure to act where the law imposes a duty, e.g., failing to care for a child, ignoring a child, and allowing a child to probably go into harm. It's even beyond moral now. It's first of all moral, then the law has gone into it to make it to go beyond the realm of moral. But generally speaking, that physical act is the mainstream. Now, some of you were saying that the intention is a separate part of it. Who can tell me where the intention is from the scenario? To kill. Yes. And if you don't think something in your heart, if you don't process something, you don't act it. When you went to go and buy that rat poison, you did not buy 5 alive. Yes. Whether you shield or not, because either of them cannot kill. You didn't buy that. You bought rat poison. And then you did it in a time and period where nobody else. So the manipulative process of the mind, if you want to kill him, you will not be putting the rat poison in his. If you put it in his presence, what will he say? He will not eat it now. But it was, you knew that it must not be there while you perpetrate your stuff. You did it. So look at it. The menstrual is the mental element or state of the mind of the offender at the time the act was committed. It includes intention, knowledge, recklessness, or criminal negligence. You are on the street and you are driving as if you are on 3rd Mainland Bridge. The law will impute it in you that you have the mental element. Because a man, it is believed that a man, when I mean a man now, I'm talking both man and woman, intends the consequences of his action. You are playing with somebody with a gun. Do you play with somebody with a gun? It is an act of negligence or whatever. Like the guys that killed the young boy in Ibadan last week. Now, was there intention to kill? What? Was there intention to kill? Yes. Omission. So the omission made him liable. Because I understand that the person raised a defense that he shot into the air.
No, he shot the head.
No, that was the argument they made.
You're shooting in a populated area.
If you are the lawyer for the state, you will have sent this guy to jail before you. Because at every corner you are cornering the guy. Yes. Even those of us that we don't handle guns, we probably know the harm it can do, right? Than those who have been trained to manage it. Well, we can process that in our mind. But again, the unfortunate thing is that the boy died. But again, I was looking at it that why on earth will the father also disobey traffic rule? Do you think that the father should be prosecuted? Please let me tell that. So what is the right thing to be done? The man should be prosecuted? No, we are not in any way making light of the situation. Are we together? We are not in any way making light of the situation, but it's also a point of learning. So in an ideal setting, should the father be prosecuted?
Yes. Yes.
Or what?
On the circumstance. Negligence.
Can you switch off this? Switch off the light so that I can see. Yes, please. Yes.
One for following the traffic laws, the normal laws, and two for failure to even protect the children with him at the point.
Okay. What about the requirement on the part of the police not to have fired in that circumstance?
This is also good because they acted unprofessionally. He also knows that there were minors. It could even have been straight to anybody before them. Yes. So he didn't act professionally. Meanwhile, he's supposed to protect, citizens and all. So he's also guilty.
Well, we always have different opinion. Yes, let's hear you, sir. The man that didn't want me to collect my 50,000 naira. Yes. Okay. Oh. Yes, sir.
Both the man and the police officer should be prosecuted for different, other different offenses. For the man, for the fact that he violated the traffic rule, he should be prosecuted. And I want to believe that that should be, that is not a criminal minor case.
Okay.
Then the other one is the police officer. He has acted recklessly. You pursue an offender.
Yeah.
He has not, the man was not carrying, at least what he was doing is harmful.
Yeah.
You have not seen him carrying a gun, attempting to carry a rob, and you are just pursuing.
Okay.
Trying to prevent or to get him arrested.
Yes.
Getting arrested does not involve shooting.
And usually, that's usually the aim. Let's catch him and deal with him. Now, let's look at this now to either wrap up this discussion. Note, motive and intention. Look at recklessness. Foreseeing the criminal responsibility of one action as a remote possibility. When you know that at the tail end, there will be consequences for your action, and you still do it. Do you know that guy, the police officer, will have succeeded in shooting at the tire of that car, and the car will stop. But he didn't look at the remoteness of the fact that there could be a miss. That's one. So the law will impute intention to cause damage in him. Negligence, not foreseeing the consequences of one action, but held responsible because he should have foreseen it. It's like you are throwing a stone into the market and you say it will not meet somebody. It will definitely meet somebody because it's what is a crowded place. Then accident, not even a reasonable man will have foreseen it happening. It's another way to look at it. If remotely there are, you don't have plenty people there, and the person actually shot into the air, yes, the bullets, there are some people, those that they are following from their village, irrespective of where they are, that thing will still meet them. Some of them is Amadiwa that will collect the bullet from the sky and take it to them, maybe because it's their time to die. But whichever way, the law will always do a proper analysis. That's why it's usually a full trial before the procedure is concluded. Okay? So with your intention and your physical acts, we bring this class to a close. I don't know if you have any question that you'd like to ask based on the conversation we've had. Anyone? I have a question.